This is the Family Law Channel. Welcome. There's been a new ruling by the California Supreme Court regarding self-representation. My guest is retired Superior Court Judge in Santa Clara, California, Eugene Hyman. Judge Hyman, welcome back.
Thank you.
So this ruling is related to those defendants who are, for example, suffering from some kind of mental illness. Can you talk about that?
Okay, what this was a California Supreme Court case that interpreted for purposes of California law how that would be applied to persons who were found capable of being tried. That is, they weren't impaired, they weren't mentally incapable of understanding and participating in their trials. Then the question is, well, what if they had some mental health impairment that was less than that, but still affected their ability to represent themselves competently? And this was a California case that was based upon a Supreme Court decision that was rendered, I believe, in the late 2000s. I think probably 2009, having to do with that kind of a situation. Under an earlier 1975 case, Ferretta, a person has the right to represent themselves, even in a death penalty case. And if they're denied that right criminally, then they're entitled to a new trial. That's an equal protection violation. So the question in California was, in terms of applying the federal case, what standards was California going to use? And what the California Supreme Court said is that you have to be careful, that as a trial judge has to be careful about making sure that a person has the right to exercise representing themselves, if that's what they wish to do, but also that if they are in fact impaired, where they won't be able to do a minimal job of representing themselves, then the trial court needs to step in and, over the objection of the individual, appoint counsel, usually a public defender, to represent them. Lots of discussion by legal commentators in terms of how far judges should go, because sometimes a judge might feel that a person is impaired where there has been no psychiatric evaluation, and the Supreme Court decision didn't give a great deal of insight to help judges in terms of what they ought to be doing in terms of making a record. So unfortunately, this is going to be revisited several more times before we have more suggestions from the Supreme Court in terms of how to handle these types of cases. But I think the best way for a trial court judge to handle this kind of case is, when in doubt, to order an evaluation. And that evaluation, even if the person is still capable of being tried, that is, they understand the charges, they are able to communicate, but they have some inability to represent themselves, then the court needs to step in. One of the concerns, however, that the Supreme Court expressed was that they did not want trial court judges overly finding that people were incapable of representing themselves and appointing counsel, just because it would be more expedient and easier to do a trial with someone represented as compared to doing someone representing themselves. Having had a number of trials with people that represent themselves, it is very difficult to do a trial with a person who's self-represented, because they don't abide by the rulings and they ask questions that are inappropriate and all those kinds of things. And the court recognizes the frustrations that a trial judge faces. However, that is not an excuse to be able to find that a person has a mental impairment just to be able to appoint representation for them.
Now, if someone has a mental illness, for example, and they represent themselves and they lose in court, could they in some way argue incompetent counsel?
No, because one of the things that a trial judge does when they give an advisement to a person who wants to represent themselves, that incompetency of counsel is not grounds for reversal when you're representing yourself. It potentially is a ground for reversal if you have appointed counsel, but not if you're representing yourself. That said, obviously, if you obviously have a mental impairment where you're incapable of doing the basic representation, then that might be grounds for reversal.
All right, Judge, thank you.
Thank you.
This is the Family Law Channel on the Legal Broadcast Network.